If a crime is committed upon the high seas, far from any sovereign land, who is this reported to? Can the offender be prosecuted? If so, by what laws? This is how Lodner attempted to analogize a contemporary issue that impacts global legal practice, the undetermined technological issue of the jurisdiction of the Internet. The Internet, perhaps, is one of the most visible aspects of globalization and in many ways its driving force. Globalization tends to be the most perceptible and observable in mostly every facet of life, mainly due to the emergence of Internet technology. For much of the world, spatial distance and national borders become irrelevant due to one's access to Internet. This therefore presents a problem, as without geographical location for a matter to attach to, the question arises, who is responsible for adjudicating the matters of the Internet? So what does this mean for contemporary global lawyers in practice? Due to the absence of rules, regulations, and policy standards for the global jurisdiction of the Internet, the global lawyer has to attempt to navigate their way through the complicated system. A system that lacks the traditional guidelines of jurisdictional boundaries, such as nations' sovereignty, territory norms. Consequently, globalization coupled with digital technologies have effectively removed lawyers from the constraints of any one jurisdiction, therefore requiring modifications to the way lawyers are educated, trained, and regulated. This jurisdictional challenge is present in the prosecution of Julian Assange, the founder of WikiLeaks, with both Britain and the US trying to attempt to prosecute him for over 10 years. Similarly, a German court failed to seize a Facebook account of a citizen, as although Facebook has an office in Hamburg, the data was located on an external server in the United States. In Australia, the case of Dow Jones and Gutnick, a unanimous decision held that Gutnick had the right to sue for defamation in Australia, even though the article in question was uploaded in New Jersey. This case demonstrates the Australian approach to this jurisdictional challenge, specifically by the judgment of Justice Callanan, outlining that if people wish to reap the benefits of different countries, they can hardly be expected to absolve the laws of those countries. Handling the coexistence of heterogeneous laws on the cross-border Internet is deemed as one of the greatest policy challenges of the 21st century. As stated by Utner in 2007, this challenge arises as the jurisdictional boundaries imposed by state sovereignty does not apply to the transnational Internet, and no internationally recognized laws, regulations, or rules surrounding this field. So where exactly does this leave us? It is understood that global companies have attempted to implement terms of service agreements which aim to dictate the jurisdiction in which legal conflicts will be resolved. Take Facebook for example. Their terms of service state that any claim or dispute must be resolved by a competent court in the country of the claim. This opens Facebook up to claims in all countries, Afghanistan to Zimbabwe, requiring knowledge and understanding of various laws, cultures, and norms. Further, these terms of service aren't always accepted by domestic courts, such as the previous case study of Facebook in Germany. This is just not sustainable and adaptable enough, especially with an increasing reliance on technology. As a global lawyer, this presents unprecedented challenges requiring a great understanding of international laws, global governance, globalization, cultural competency, and digital capabilities. Upon confrontation of this challenge, the legal practice needs to take the emic perspective and adapt to become a more cosmopolitan lawyer. Many academics and scholars have attempted to utilize this theory of cosmopolitanism to propose solutions for the challenge the Internet presents. Rice 2000 proposes a specialized Internet jurisdiction where cyberspace has its own legal order, however does not adequately take into consideration our state-sovereign Westphalian world. Although this would be the ideal solution, the current dynamics of states would not accept external jurisdiction over their power. Malcolm 2008 proposed a multi-stakeholder unifying policy standard based upon an international agreement or treaty. As treaties are not compulsory to all states, are not binding on domestic laws, and require ratification to take effect, this proposal presents evident hurdles to overcome. However, the TRIPS agreement has proven a precedent for how these hurdles can be overcome by presenting the solution as more of a guideline for states instead of an international treaty. The development of this multi-stakeholder standard will provide an international guideline on how to approach the jurisdiction of the Internet and assist global lawyers to present a more unified and strategic approach. This approach would allow for global participation and decentralized processes, allowing a diverse range of stakeholders. Accompanied by these guidelines, a global lawyer would need to be greatly trained, educated, and regulated in this process to promote uniformity. This is the most realistic and adaptable solution for the newly globalized world and its evident challenges the jurisdiction of the Internet presents.